The Kansas Supreme Court upholds property rights in an outstanding ag nuisance case, ruling the state's right to farm law didn't apply due to trespassing. It's a case that could have some big takeaways for all farming operations. Now, Roger McEowen with the Washburn School of Law joins us now with the highlights. Roger, good to have you with us. Let's start with a brief background on this case and the lower court's ruling.
Well, good to be with you today, Tammy. In this instance, the defendant owned multiple farming operations, including a large-scale hog confinement operation, and he installed about 2 miles worth of pipeline in the road ditch right-of-way across neighboring tracts, adjacent to a public road to transport liquefied hog waste to spread on his crop fields 2 miles down the road. He didn't get the adjacent landowner's permission, and he didn't follow applicable county permitting process. And that liquefied hog manure was sprayed from a pivot irrigation system with an end gun on it within 200 feet of a home of the plaintiffs in this case. And so they're also farmers, the plaintiffs were, and they sued for trespass as well as nuisance. And the spray from the pivot came within 200 feet of one of their homes. And he lost at the trial court and was hit with a total judgment of just under $200,000. And the appellate court affirmed, and he sought review by the Kansas Supreme Court.
So what all contributed to the Kansas Supreme Court ruling?
Well, first of all, the Kansas Supreme Court affirmed the lower courts on every single point, and he claimed he was protected from a nuisance lawsuit by the state right to farm law. All states have a right to farm law, and that's a key point here. And so you have to know the specifics of your state law. But in the Kansas case, in the Kansas right to farm law, you have to be in compliance with all state and federal laws to get the protection of the right to farm statute. He wasn't. He had committed a trespass. And he claimed that he didn't because the law of trespass is part of the common law, and he said he only had to comply with statutory law. The court didn't agree with that. They said, no, law means all law, including court-made law as well as statutory law. And so since he was committing a trespass, he was not in conformance with all of the state laws, and he couldn't use the right to farm statute to protect his conduct.
So what do you think this can mean for farmers when it comes to property rights and the right to farm laws?
Well, a couple of interesting things here. The plaintiffs in this case were farmers. So usually we have non-farmers that are suing farmers for nuisance-type related claims. And here it was a neighboring farm operation that sued. And every state has its own right to farm law. And each state's particular requirements of those laws are different. And a common requirement is that you have to be in compliance with all state laws and federal laws, get your permits and all of that might be necessary to use the right to farm law. So know the nuances of your state law and make sure you're in compliance with that. And if you have any questions, make sure you talk to an attorney that deals with these issues first.
All right. Thanks for that update. That's Roger McEowen with the Washburn School of Law. Always good to talk with you.